legal issues for carers. As Michelle has just kind of raised in her comment, we find these sessions quite difficult to separate out. And she was asking the question, is it from a point of view of the carer or the person being cared for? And I would hope to suggest the answer is perhaps a bit of both. It might apply to you, it might apply to the person you're supporting. But again, it's just a case of raising knowledge about these complicated and difficult things. For those of you who don't know the Care Advice Line, we've been commissioned now remarkably for 10 years by GCC, specifically to provide help and guidance on issues of care funding and things related. So this is part of our sequence, really. But I'm picking on three particular items. I'm going to very quickly recap on lasting power of attorney for those who haven't attended our lasting power of attorney session. We have a full 1 hour on that, such is the nature of the issue. But for those who haven't attended, I will just touch on that. I then want to look at inheritance tax, mainly so that people can be aware of it, can maybe just check whether it applies to them, and maybe think about things that they might do about it because it falls within this legal framework. And then the final section, which is in many ways the most important, is to look at wills and how you might consider them in the context of care, and just some pitfalls to watch out for, some issues to think about, and a bit of guidance on how you might go about that. Now, we do actually have a sort of wills and estate session booked in for March, mainly because next month is free wills month. So we will be doing a session specifically on that. So if you find our general introduction isn't quite enough and you want to know more, then our next month's session may well help. So obviously, with 45 minutes today to cover those three subjects, that's fairly tall order. So let's rattle on. As I say, I will resume the issue of lasting power of attorney just to make sure we're all clear about it. Even the very name lasting power of attorney we find extremely confusing. So a better way to think about it is acting on somebody else's behalf. How do you have the legal authority to do things that somebody would ordinarily do for themselves but are no longer able to, either because they don't have the capacity, or, to be honest, more often because they just can't be bothered. They just don't want to have to spend 45 minutes waiting on the phone to speak to British Gas to give them a meter reading. So there are two types of LPAs. Property and affairs, that would authorise somebody to deal with your money, your investments, your bills, your bank account. And then the separate one is health and welfare, as the name suggests. That would be used to deal with issues of medical treatment, moving into a care home, consent for operations, that sort of thing. It's important to remember, because I find lots of people mistakenly think that once you've written one of these documents, that's okay. That's not the case. You have to have them registered with the Office of the Public Guardian. They have to stamp them in order for them to become valid. And that process can take anything up to 20 weeks. The wait time is getting smaller, thankfully, but it's still quite a while. So it's important to try and get those in as early as possible. Two other key differences just to bear in mind. The health and welfare option can only commence when the person concerned has lost their capacity. As you can imagine, it wouldn't be appropriate for somebody to be making decisions about somebody's health while they were perfectly able to do so themselves. But with the property and affairs, it can commence immediately, even when you haven't lost capacity. And I mention that because of this issue of convenience. As I say, I would say half of the work I see being done by an attorney is not because the person is no longer able to, but just because they don't want to, or it's too much trouble, or they're not feeling up to it. So those are the two big distinctions. When you're appointing an attorney, my advice is always to have two. Common arrangement would be spouse or partner, and a younger family member, son or daughter. Why do I say that? Because quite often those convenience things are just done by the person you live with. And then you've got your son or your daughter or your younger family member in place, should they be needed to kind of act as reserve, or might be a good way of thinking about it. And you can appoint people to act when there's more than one of them, either jointly, which means everybody has to agree to every item. Not a good idea, because that, if somebody's on holiday, it brings the whole process to a standstill. But always a good idea to have the appointment made jointly and severally, which means either person can act or they can act together. Just two other quick points. There are sections in the power of attorney document for you to make restrictions and limits. A common one I've seen, well, not common, but I have seen it. You can do everything, but you can't sell my house. And of course, the problem with that is if a care need arises, that's quite often, if you're moving into a care home, that might be one of the most important things to do. So my recommendation would be, don't put limitations. If you don't trust the person to do everything, then maybe look for somebody else. So I've mentioned all of those things, in case you've not come across this issue before. And if you have any questions on that, we're more than happy to have a chat with you separately on the helpline. If you already have a power of attorney in place, I would urge you to go and just have a look and make sure that you haven't inadvertently made the appointment jointly when you actually should have had it jointly and severally. Three final elements I would just mention on that. There are 2 or 3 problems and things that prevent people from setting powers of attorney up. First one is obviously, do they have the capacity to do so? And quite often I hear people say, well, I'm not sure. And that's because capacity fluctuates. I meet people who are great in the morning, and by lunchtime, they wouldn't be deemed to have capacity. I see people who are really good after they've had their medication, or really bad after they've had medication. So you only have to have capacity at the moment you make the appointment for that kind of split second in time. You may not have it 2 hours later, but that doesn't mean that you're not able to do it. So a good solicitor, or somebody who's helping you with a difficult situation, I would expect them to make several attempts if on the first occasion the person doesn't have capacity. The other thing that stops people doing it, apart from the fact it's not the most engaging subject, is that there's a requirement for somebody to act as what's called a certificate provider. They basically sign the document to confirm that there's been no coercion, that the person isn't making this declaration when they're not able to. And that can put people off. It feels a little bit intimidating, perhaps. But you can go to your doctor, your solicitor, for them to perform that task. The only problem is they will charge you for it. And they're a little bit reluctant because they're nervous about their insurance policies. You don't have to be a professional. You merely have to have known the person for 2 years. So a neighbour or a friend can act in this capacity, but they cannot be one of the persons appointed in the document. So your attorney can't act as your certificate provider, if that makes sense. And that quite often is one of the reasons why documents get sent back. The other role in there is there's a witness. A person has to sign to witness the documents. And again, that gets people a little bit scared. You are not interested in the content, who's been appointed or what conditions apply. All you are saying is, I watched Mr. Jones, I saw him sign this document on this date, and that's all that you're doing. So don't let these issues put you off. If you've got one, check it. If you haven't yet set up a power of attorney, do so. I would encourage everyone to have one. You can do them by post, you can do them online, you can go in. Well, I used to say WH Smith. I don't think they're WH Smith anymore, but you can go in the post office and buy a DIY power of attorney pack for, I think, £10. But you've got to just make sure you know kind of what you're doing. And the other thing that puts people off is it's £92 to have your document registered with the court. So if there's husband and wife, 2 appointments each, then 4 times 92, your maths is probably better than mine. That's another thing that has handicapped the take-up rate. But just have a think about what happens if you don't have one. Because if you don't have an appointment and capacity is lost, and you have to then apply to the court, they treat you a little bit kind of like a criminal. They assume that the reason Dad didn't appoint you as his attorney is because he didn't trust you, not that he'd forgotten or didn't know about it or had lost capacity by the time the issue arose. They don't treat you terribly sympathetic. So you kind of have to prove your entitlement to be a deputy, which is the alternative to power of attorney. Takes ages, very intrusive, expensive. I would expect it could cost you easily £3,000, and just not pleasant. So beware the consequences, really. So that to me is the start point of any legal discussion about somebody with a care need. Make sure you have that authority. And I do meet people who say that they have the right to speak to the bank, for example, about an account. They confuse that as though that is a power of attorney. It isn't. It's merely an arrangement on a particular account. A utilities account is probably the most common. And without this document, it really is hard work. It makes a difficult job twice as hard. So make sure you've got it, make sure it's valid, and make sure it has all the right bits in it that you need it to have. Any issues, please give us a shout. And as I say, we do have a 4-hour session about power of attorney that takes all those issues in a bit more detail and then progresses in terms of how you might use them and what you might do with them. So the second subject, which may seem slightly odd that I wanted to just touch on, is inheritance tax. And I say this because although this is a session about legal issues, and you could argue that inheritance tax is a tax matter, of course it is, but what it might be worth knowing is that many of the solutions or the issues or the problems arising around inheritance tax are resolved through legal procedures and processes. Hopefully this will make sense as we just go through this. So first thing to do is to make sure if you are the attorney for somebody, or if you are the carer for somebody, and they're no longer able to deal with their affairs, as a property and affairs attorney, I would encourage you to find out or have a look and see whether or not this person has an inheritance tax issue, because it may affect the decisions that you make in terms of their care need. And I'll give you some examples as to how that works in a moment. So let's just remind ourselves of what inheritance tax is, when it applies, and why are there specific care issues that we need to think about. So first of all, it is charged at the horrific rate, 40%, on everybody who has an estate above £325,000. So if you have a property at the average property value, you are in danger of being pretty close to the inheritance tax limit. Now, I mentioned property. If you are a property owner, you can claim an additional, potentially you can claim an additional allowance, and it's called the residential nil rate band. So the first nil rate band is just for everybody, and then there's the residential nil rate band. And as the name suggests, it is only available to people who have a house. The maximum amount that you can have under that claim is £175,000, or the value of your share in the property if that's lower. So if you had a half share in a £300,000 house, then your entitlement would only be limited to £150,000. Equally, if you own a house worth £700,000, you would only be able to claim the residential nil rate band at £125,000. So if you add those two together, you could have an exemption of £500,000, potentially for a couple, then that can ratchet up to the £1 million that we often hear about. But unfortunately, the devil, as ever with these things, is in the detail. So a couple of things to bear in mind. The first one is that you can only have the residential mill rate band if you leave your property to a direct descendant. And by that, they generally mean to a lineal blood relative, although there are extensions of that. A child, a grandchild, children thereof, that would be the obvious ones. Stepchildren are also included. Adopted children are also included. A child that was fostered is also included. But what are not included, which is maybe more the point, are nephews, nieces, siblings, and other relatives who aren't in that list above. Now, I have no idea why the person you leave the money to should have any bearing on whether or not you're entitled to this exemption, but that's the way it is. And I can't give you an explanation. It seems illogical to me. But this residential nil rate band, which is the bit that often gets overlooked, is hugely complicated and confusing. So let me explain why. Let's imagine that you've got a husband and wife, and the husband may have died 20 years ago. And long before this thing ever came into being, long before it was ever introduced. What people don't realize is that when their wife dies today, they're able to claim their husband's £175,000 allowance on the same property, even though he died long before it came into being. And people just don't realize that that's the case. And that's, again, part of why you can build up your allowances to this £1 million mark. The other care-related issue that is a really important one is you can only normally claim this allowance if you own a property at the time you die. However, the government has recognised that that's not fair to people who might sell their house to move into care or might downsize because of the care need. They might sell their 3-bedroom house and move into a sheltered accommodation property. So there are rules whereby this allowance can be claimed. I'll quickly explain. The main one is that if the property was sold, given away, or downsized after the 8th of July 2015, so anybody who's done this in the last 10 years would be able to claim this allowance, providing the home that they sold would have qualified had they kept it, which is very reasonable. And because, of course, they can't now apply the absolute issue of lineal descendants, the rules say so long as a direct descendant inherits at least some of the estate. So they soften the terms. So there are ways. It's important that people are aware of that. Don't let inheritance tax be a reason not to maybe downsize your house if you need different accommodation as your care need develops, because you can still claim it. Thing to bear in mind is it's not given to you automatically. You have to go and claim it. And because of that, you need all the information to hand. So when was it sold? How much for? Copies of the documentation relating to the sale, usually the final statement that the solicitor gives you, setting out the details. All of that will help you make that claim what might be 10, 20 years later. So important to have all those issues in mind. The other reason I've mentioned inheritance tax in this session is because of the change that's coming in next year, which will bring pensions, personal pensions, into the remit of inheritance tax. So there will be lots and lots of people who, prior to next April, not this April, April 27th, who didn't have an inheritance tax problem. And now they will have, simply because of the changing government rules about the treatment of pensions. So you have to include the full value. I was speaking to a chap a couple of weeks ago, and he had 362,000, I think it was, in a pension, a private pension that he hadn't drawn on. and he was now about to draw upon it because he now had a care need. So he assumed that only the bit that he drew out would count towards this inheritance tax computation. And I had to explain that that's not the case. The full 362,000, or whatever that value goes up or down to, now forms part of the equation. So there's all sorts of estimates being suggested about how many millions of people will now be caught by this, but possibly don't realise it. It wasn't common 10 years ago for people in care to not have used their pension, but because pensions were encouraged as a means of leaving inheritances to your family without tax, lots of people did exactly that. And now we've got a complete reversal. So again, as attorney or as carer, I think it's useful to just have a look and understand what the position is. If there isn't an inheritance tax liability, great. If there is, it might affect your thinking. And you may be sat there thinking, in what way? If you were funding your care through, for example, a care annuity, this is one of these arrangements where you give a lump sum to an insurance company and they take over your care fees. We find probably 25 to 30% of people choose that route. Then it can have a particular advantage because the price that you pay takes money out of the person's estate. So you could, in theory, get a 40% discount, being the inheritance tax rate, on the purchase of that plan. So whereas you might have been a bit unsure if it was a good idea, a 40% discount makes it look quite attractive. So again, knowing this information, knowing whether there is an IHT bill might affect the legal decision you take about should we or shouldn't we fund in a particular way. I'm not going to spend a huge amount of time on mitigating IHT. If you find that a person has it, as I say, the care annuity is one possible option. But I get quite a few people who ask us, well, what can I do to stop it? And the most obvious one is that you are allowed to make certain gifts within a year. They're not huge. £3,000 is the capital amount that you can gift. There are rules that allow you to give more, but you have to survive 7 years. And there are rules that allow you to give your spare income. So if your income is £30,000 and your expenditure is 20, the HMRC suggests that you could give the 10 away. But this is where it really causes an issue for people with a care need, is because on our helpline, we get people quoting the inheritance tax rules to us constantly, 7 years, £3,000. Those are all perfect, legitimately IHT rules, but they are not care rules. So if you give £3,000 away because the inheritance tax rules says you can, the care system doesn't agree. It says you can't, because you are then in danger of depriving yourself of capital that otherwise would have been funded for care. So what you've really got is a clash between families and people who are trying to reduce and manage their estate for inheritance tax purposes, but run the real risk of falling foul of the deprivation rules. So you have to be ultra careful. We could spend two hours on that subject alone. So my aim today is merely to make people aware of it and to think about it, and to then get a bit of extra help and guidance and advice if that situation should apply to them, because it's important. So hopefully that all makes sense. There are also other schemes available, I should just mention, specifically for inheritance tax planning. And if they are done carefully and well documented, it is perfectly possible for you to not fall foul of the deprivation rules, but you really just have to take care, be careful, and make sure you've done it with advice, because that's quite a critical part of it. So having flipped over to inheritance tax, I want to come back now and deal with the main subject, if you like, that I wanted to cover today, which is wills. Because ultimately your will in many respects, directs what happens in terms of your inheritance tax. But our subject today is to look at how it might impact on care. And there are a couple of things I wanted to raise that you should be aware of. The most common one, and it is still the most usual arrangement I see in any will I look at, is that we all have a common arrangement whereby the husband leaves everything to his wife and thereafter to the children, and vice versa. And these are commonly called mirror wills. For obvious reasons, they reflect the same view. Nothing wrong with them, entirely as you would expect people to arrange their affairs. Why wouldn't you do it that way? The thing I wanted to raise is that from a context of care, it creates a potential problem. And that problem is that it concentrates wealth in the hands of whichever person survives last. That makes sense. So if you had that situation, husband and wife, everything left to each other, and thereafter the children, on the first death, the person who's left has got all of the money that the couple had when they were both alive. Now, if they then need care, all of that money would be available under the means test, and they would be expected to spend it all until before they could make a claim against the local authority for help. So what I would say to people is have a think about whether you actually want to do that. Again, it sounds quite dramatic, but would it be better for you to disinherit each other? In other words, not leave everything husband to wife, wife to husband, but instead send it to either the family, would be one option. Better still, to send it to a trust so that the second person, the person who's still here, doesn't have all the money in their hands should they develop a care need in the future, which is quite common, particularly when the first person to die was either a prime carer or at least partially a carer. I will give you a couple of examples of how that works, but in order to do that, in order to leave your share of your property or your assets or your bank account to somebody other than each other, you can't do that if the asset is owned jointly. So let's take a simple bank account. Husband and wife have a bank account, £10,000 in it. Even if in their will they said, I want all my money to go to my son, the bank will not do that. The bank will send your share of your joint account to the other joint account owner. In other words, it overrides your legal instruction. That's fine for cash accounts where there's modest amounts in them, but I meet lots of people who have £50,000 in a joint account, unaware, and they've written a will that says, I want my money to go to my son and whatever arrangements they've set, completely unaware that that is not going to happen while they have that money in a joint account. They would have to have two accounts, one of £25,000 each. Now, you can still have a joint account that is fed by your two private accounts just to keep a small amount in a joint account to cover the bills, but don't have large amounts in there unless you're aware and understand the consequences. Of course, the property, your house, is the bigger example of this. Still fairly common for most people to own their houses jointly, which means they both own 100%. Now, there is a legal alternative to that for property, which is to own your house as tenants in common. It's a ridiculous title, strange terminology, dates back many years, but that's the alternative to owning your house jointly. You own it as tenants in common, which actually means you each own separately half of it, or whichever proportion. You know, it doesn't have to be half, it could be 60-40, 70-30, it doesn't matter, but you own it separately. And the relevance of that arrangement is it means that you can then leave your share to somebody other than the other owner. It opens up that legal arrangement. So how do you do that? Well, you have to do something. Again, sounds fairly dramatic. You have to sever the tenancy, which is fairly painless. and is a one-page document that just basically says we want to change this property from being owned jointly to being owned tenants in common. And that is an inexpensive process. That gets registered at the land registry, and then your will can be changed so that you can leave your respective half to somebody other than each other. So let's think about that in a real life care context. Let's take a typical property value in Gloucestershire that might be, I don't know, £350,000, let's say, and we'll take my £50,000 example of a joint bank account. So there we are with a couple, husband and wife, with £400,000 and a mirror will, leaving everything to each other. First person passes away. The survivor then owns everything. They own the house, all of it. They own the joint account, all of it, irrespective of what the will may have said. So obviously then, if they then need care, they will not receive any help from the government or from the local authority until such times as they've spent that down to the 23,250 level, which is obviously going to take quite a while. So the alternative would be change the joint account into two accounts of £25,000 each, change the ownership of the property to tenants in common rather than joint tenants, and write a new will where each of them says, I leave my estate to my son and daughter, or better still, as I said, to a trust. I'll explain that in a bit more detail in a moment, to a family trust. So then on first death, the survivor only has £200,000 of assets, their share of the house and their share of the money that was in a bank account, which is going to bring them into a position of getting help with their care should they need it an awful lot faster than otherwise would have been the case. That other £200,000 is effectively now protected or ring fenced. This is where the trust idea comes in. Because if you do ultimately become reliant on the local authority for your funding, that trust fund can help pay your top up. In other words, you'll be able to choose a home that charges more than the local authority will pay, and the trust fund is in a position to make that payment. So a massively different outcome. And all we've done, we haven't really changed anything. We've just restructured the legal arrangements of these people so that they've got a more favourable outcome. Now, we have the same issues in changing wills as we had in terms of powers of attorney. You've got to have the capacity to do it. It is worth bearing in mind that the capacity to write a will is not the same as the capacity to appoint an attorney. It's actually simpler. You have to be less capable to be able to rewrite your will because it's a simpler proposition. Anyway, what that really tells us is we should be thinking about this as early as possible when there is the hint. Well, I say when there's a hint of a care need on the horizon. I would argue you should do this as part of your normal planning because we never know who this is going to affect. But better to have these things known and aware about so that you can think, does this apply to me? Do I want to make that change? I'm not saying you have to do this. I'm merely saying you should be aware of the consequences if you don't. And of course, if you're acting as carer, let's imagine that is for mum and dad, they're probably, if they've not been made aware of this before and haven't acted, then they won't know. And it kind of falls upon you to say to them, is this worth looking at? Should we make a change? Should we revise the way that this arrangement is set up? We are often asked, excuse me, about the issue of putting property into a trust before somebody dies in order to protect from care. Now, that is a very, very different proposition to the one I've just described. There is no possibility of what I've just suggested as being treated as deprivation. The reason for that is that the person who has not received the other person's share of the house, i.e. the spouse, had no control of it. Their husband decided not to leave it to them. That's not deprivation. You just didn't receive it. You can't be held responsible for things that didn't happen. Whereas if you say, while I'm alive, I am going to pick up my house, metaphorically speaking, from a deed point of view and put it into this trust, then that is an act that you have undertaken. You didn't have to do it, and therefore you're accountable under the deprivation rules. You'll see these trusts promoted and advertised in lots of different ways. Quite often they're called probate trusts. And there are some, shall we say, less than scrupulous people who will suggest that these are a perfect way of avoiding having to pay for probate. You take your house and put it into a probate trust, then you don't own it when you die, therefore there's no need to make a probate application. And as a secondary issue, they'll say, oh, and it probably means you won't have to pay for care. Be very careful as to whether or not that will turn out to be true. Because if a care need arises soon after you've done that, you will fall foul of the rules. If you even thought you might have a care need, you're likely to fall foul of the rules. Anything that you do that could be triggered by, all the local authority would do is say, well, isn't it strange you made the decision to move your property into a trust 6 weeks after you had a stroke or were diagnosed with dementia or whatever it might be. They can go and just say, look, there is the motivation. So be very careful. The thing about these things is they'll cost usually upwards of about £3,000 or £4,000 to set up, but you won't find out if it works until it happens. So my suggestion would be just take care. So if you just take those three subjects that we've covered: power of attorney to give you the authority to act, inheritance tax so that you know what exposure the estate is likely to have to tax in the fullness of time and how that might affect your thinking. Might that make you want to look down the route of gifts? Might that make the purchase of a care annuity a better way to fund your care? And is there any scope to make any changes to the will? All of these can help to just improve the overall financial position, and just make the outcome a little bit better. It's worth bearing in mind that going back to the reason of appointing an attorney that I mentioned at the beginning, one of the legal requirements of an attorney is to maximise the person's estate. In other words, to leave as much money there to be dealt with through their will as possible. If you are the attorney and you are the beneficiary, so if you're an only child and your dad's attorney and you're his beneficiary in the will, then you are one and the same person. But if those people are different, it is not impossible for the beneficiaries of a will to take legal action against the attorney because they didn't fulfill their legal obligation of maximising the estate. So there are some quite serious and important legal principles that sit behind it. And you may say, oh, our family's great, we all get on brilliantly, nobody's going to have an issue. Not all families fall into that category, and not all families stay in that category. We've all seen situations where fallouts can develop, problems can arise. So my overarching guidance and advice to you is whatever you do, however you go about this, even if you don't do something, it's always a good idea to have shown that you've looked at it, considered it, taken advice on it, and acted accordingly. And then that way you are completely safe, if you like, in terms of somebody coming along later and saying, well, why didn't you buy the care annuity? Why didn't you do something about the family, about the IHT situation? So it's a protection measure as much as anything, and also making sure that you're getting the best situation out of a difficult position. So I know it's tough enough being a carer, supporting somebody with all the things that come with it. What I've just described is just a whole nother level of work to be done. So get some help. There is nothing wrong with you paying as an attorney, you paying somebody to give you advice to help you get through these things. And the areas I would suggest you look at, one would be From a financial point of view, I would advocate you should look at the Society of Later Life Advisors, SOLA. You can go on their website, you can type in your postcode, it'll give you a list of members within your postcode area or a kind of 50-mile radius. And you can have a look at those and maybe choose somebody who you like the look of or is close by, have a chat with them, see if you can get the information and guidance that you need. And on the flip side, from a kind of legal point of view, I would suggest you look at Lifetime Lawyers. That's a bit the same idea. That's an association of solicitors who have demonstrated a specialism in dealing with issues for older and vulnerable people. So you're not just going to somebody who would deal with a normal, a matrimonial issue or a house conveyance. These are people who have demonstrated expertise in this area. So at least you're getting some real guidance that's relevant to your situation from people who will understand the situation you're in. And again, same issue. I think there are 1,500 members of Lifetime Lawyers, and you can go on their website and again, type in your postcode and find people in your area. So my parting comment really is think about it, have a look, and then if you need advice, be prepared to go off and get some assistance so that you get things right. So that brings us bang on time, 45 minutes. We've completed our session. So I'm going